Olá, pessoal. Liara, você é a primeira oradora do Respondent, é isso? Só para confirmar os dados, Liara, você será a primeira oradora do Respondent e irá falar por 15 minutos, está correto? E sua colega também 15 minutos, Maria Beatriz Montenegro.
Oi, Rui, é isso mesmo. Consegue me ouvir?
Consigo sim, Maria.
Certo. Eu não sei por que a Liara não está conseguindo.
Quer testar o microfone, Liara? Você está mutada agora. Se quiser ligar a câmera também para testar, fiquem à vontade. Os juízes já estão na sala separada, esperando.
Foi, ela mandou mensagem aqui de que está tendo alguns problemas técnicos. Pelo menos está respondendo aqui. Mas acho que já
Ok.
está agindo.
Se quiser sair e entrar novamente, fique à vontade.
Oi, gente, estão me ouvindo?
Sim.
Conseguimos te ouvir sim agora, Liara.
Tá,
Se
pronto,
quiser testar a
resolvi.
câmera desde já, pode testar
Tá.
também. Conseguimos
Conseguem?
te ver também.
Tá certo. Obrigada.
Perfeito. Nada?
Rui, eu vou sair e entrar de novo porque minha câmera tá preta. Eu acho que foi algum problema.
Tranquilo.
Já vou voltar.
Tranquilo. Maria, você já consegue ligar?
Não tô conseguindo. Quando eu clico em começar vídeo, a mensagem é que o Zoom não foi capaz de detectar uma câmera, Mas eu testei, acho que 15 minutos atrás. Eu entrei na sala para ver como tava. E eu reiniciei o computador agora.
Você tá pelo computador, então, né?
Tô,
Vamos
mas
lá, vou te
calma.
orientar aqui. Vá para configurações do Zoom. Deve ser arquivo, configurações, provavelmente. Vá em vídeo. Configurações ou preferências. Aqui no meu computador se chama preferências. Aí vai em vídeo. Aparece sua visualização de vídeo aí? Sua câmera?
Não, as configurações seriam onde? Aqui na chamada?
Não, assim, perdão. Seu computador é Windows?
É.
Eu creio que fique
Achei.
Achou? Ah, ok.
Vídeo, certo. Tá cinza a câmera.
Essa câmera tá cinza, né? Embaixo de onde estaria o vídeo que tá cinza, tem escrito câmera, e aí tem para selecionar, tem um drop-down para selecionar qual é a câmera que você quer usar.
Não tem nenhuma
Sua câmera?
opção.
Não tem nenhuma
Não.
opção, né? Então,
Rapaz.
você poderia tentar pelo celular?
Tá. E meus documentos que estariam abertos em PDF na tela?
Você pode continuar usando. Você pode continuar usando o computador e você usa o Zoom do celular apenas para transmitir sua imagem e voz. E se quiser, você pode permanecer com o Zoom com outra conta que você tem aberta no computador para poder ver as pessoas maiores do que na tela do celular.
Tá, eu vou continuar tentando, mas já estou aqui baixando o aplicativo no Zoom do celular. Do Zoom.
Certo, tranquilo.
Nossa Senhora.
Rui?
Olá, Liara.
Só para confirmar, tá aparecendo para mim aqui nessa tela que a gente está no Zoom, uma página em branco com o nome Meeting Topic, brasileiro tributário, aí tem, enfim, uma página em branco com alguns dados. Eu não tô te vendo. Tá certo, né?
Calma. Só admitir as pessoas que estão pedindo para entrar aqui para eu tentar entender. Quem falou comigo foi Liara?
Isso.
Pronto, Liara. Você está conseguindo ver aqui o nome de algumas pessoas? Meu nome tá IBMC apenas. É isso?
Não, eu só estou vendo uma página branca com o nome Meeting Topics, Multi Brasileiro de Direito Tributário, Host, Password,
Isso na ligação do Zoom que você está?
Isso, na ligação do Zoom que eu estou. Em cima eu vejo o nome Talking quando eu estou falando, ou então quando você está falando aparece o nome da pessoa que está falando, mas eu não consigo ver ninguém. Deixa eu ver.
Eu vou ligar minha câmera aqui para ver se você consegue ver. Tô colocando a placa aqui, número 5.
Tô conseguindo ver agora.
Então tá funcionando, porque ninguém tava com a câmera ligada.
Tá certo, então tudo bem.
Olá, Roberta, consegue me ouvir?
Olá, consigo sim. É que está aparecendo Marina, que é o nome da minha filha. Eu não
Isso,
consegui
tranquilo.
tirar o
Sem
nome dela que
problemas.
ela usa para fazer o homeschooling.
Pronto, eu vou te transferir para a sala com os juízes. A Mariana Chorato está lá para orientar vocês.
Tá bom.
E é só esperar que vai ser transferido automaticamente.
Muito obrigada.
Ok, então, Liara, você conseguiu ver minha câmera quando foi ligada, correto?
Isso, consegui.
Perfeito. Então, a Jade já entrou aqui também. Você é a segunda oradora do time 2502 Applicant, correto?
Correto, Luiz.
Perfeito. É Jade Leal o nome, não é?
Isso.
Tá. A Maria Beatriz Liara tem notícias? Ela conseguiu baixar o Zoom pelo celular?
Eu tô aqui tentando falar com ela. Eu vou qualquer resposta que ela
Certo.
deu, eu falo novamente.
Ela tá entrando aqui agora, vamos ver. E ela é, junto com você, respondent. Então, pelo menos, ainda tem algum tempo, caso haja alguma atraso.
Verdade.
Olá, Maria, consegue me ouvir?
Tá, agora pegou, graças a Deus.
Perfeito, tudo funcionando. Eu vou alterar aqui o seu nome. Você vai ser 2503 respondent, não é isso? R, né? Pronto. 2503R, junto com Liara. Só para dar a última confirmação em relação ao tempo de vocês, nós temos aqui Leonardo Libório, 15 minutos, Jade Leal, 12 minutos, rebuttal de 3 minutos. Para o time do Respondent, 15 minutos para cada uma das oradoras. Todo mundo correto?
Isso.
Perfeito,
Isso,
então.
correto.
Ok, então já estamos prontos aqui na sala principal. Se possível, já desliguem suas câmeras. Eu vou pedir para que os juízes sejam trazidos para cá. Há 4 juízes nessa rodada. O tempo será feito através das placas, normalmente, pois a gente testou a opção do vídeo, e quando a vídeo está sendo transmitido no Zoom, ele ocupa quase que a tela inteira. E aí os juízes e os demais oradores ficam muito pequenos, o que a gente achou que não é uma experiência muito boa. Então vai continuar normalmente com as placas sendo mostradas por Mariana. Perguntando para a equipe 2502 que estava na outra rodada, os resultados vocês conseguiram acessar tranquilamente pelo site?
Sim, Rui, certinho.
Saiu rapidinho. Deu para verificar tudo certo e anunciar. Se possível, nessa rodada a gente já anuncia mesmo no final da rodada aqui no vídeo. Pronto, todos já estão aqui. Mari, pode então dar início.
Hi everyone. Everybody's listening. Everybody seeing me. Welcome. Now we officially begin the second round of the preliminary phase. If you, Mr. President, if you want to start, time is yours.
Right. So would please the first agent for the applicant approach the bench.
Good morning, Madam President, Your Excellencies, agents for the respondent. May it please the court. My name is Leonardo de Borges Diniz Gonçalves, and with my co-agent, Ms. Jade Leal, I have the honor of appearing on behalf of the Federal States of Alducra, the applicant in the present case. In today's proceedings, I'll be addressing for 15 minutes why Rombetti violated international law with its wind farm project, and then my co-agent will discuss for 12 minutes why Alducra complied with international law with respect to its trade measures for tapagem products. Following, we would like to yield 3 minutes for our rebuttal. If Your Excellencies have no preliminary observations, would you like a brief statement of the facts?
That's okay, agent, you may proceed.
Your Excellencies, moving to the application, the first topic of our submission is that Rombetti violated international law with its wind farm project and operation. Firstly, by violating the duty not to cause and to prevent transboundary harm. The wind farm posed as an obstacle to the bats, impairing the connectivity of the roads of the migratory species and threatening the biodiversity of Alducra's territory, thus violating Article 8 of CBD and CMS Resolution 12.7. Your Excellencies, it is important to mention the concept of connectivity. When we are facing a migratory species that live in more than one location, such as the royal nocturnal bat, in order to maintain the biodiversity of the ecosystem and the health of that species, there must be a connectivity between the two areas. That is, one cannot impose obstacles which interfere in the migration. Thus, the transboundary harm is evident in the present case, considering the ecosystem losses derived from the royal nocturnal bat's casualties. The respondent's wind farm project has caused several royal nocturnal bat losses. Indeed, there is a causal link between the wind farm and the bat fatalities. According to Paul Cryan from the United
States. Leonardo, I'm sorry. I think you may listen your arguments. Maybe you should speak freely. It's easier for the judge to understand.
If I could add, agent, a question. Let's talk about where the bats are found dead. Is it in your territory or the territory of the respondent state?
It is on the border between the two areas, Your Excellency. It's indeed it's on the territory of Rombetti, but it represents an extraterritorial measure, thus causing transboundary harm to Alducra.
But isn't it true that to have a transboundary harm, we need to find evidence that the damage indeed was carried out throughout the state, not only in the respondent state, but also in your state, for you to be addressing this issue before this court?
Indeed, Madam President. Nonetheless, the royal nocturnal bats represent several important ecological functions, such as insect control. And with the bat fatalities occurring, there would be detrimental effects on the ecology system from Alducra. And therefore, the pest will be increased. The pests, insect pests, the pollination of the plants would be destroyed, and several consequences from the bat fatalities would impair the biodiversity from Alducra's territory. Therefore, we are facing a transboundary harm in the present case. Indeed, there is a causal link between the wind farm and the bat fatalities. According to Paul Cryan from the United States Geological Survey, the fatality rates of bats on wind turbines in North America is around 11 bats per megawatt per year, representing hundreds of thousands of dead bats at turbines each year in North America. Your Excellencies, Rumbetti, Rumbetti wind farm has a capacity of 300 megawatts, regarding only the first phase of construction. Therefore, the amount of bat fatalities is estimated in more than 3,000 per year, and this number will certainly increase if the respondents do not take mitigation measures once the wind farm will grow in its megawatts capacity. The fact that royal noctule bats were found dead near the wind turbines confirms even further the causal link in the present case. Your Excellencies, the royal noctule bat is the endangered species responsible for ecosystems, as I previously mentioned. Moreover, transboundary harm means a significant harm to a state's environment or wildlife as a result of human activities held in another country. And indeed, a significant harm can be found on the detrimental consequences that the wind farm brought to Alducra. Article 14 of the Convention on Biological Diversity and customary international law require parties to conduct an environmental impact assessment of its proposed projects that are likely to have significant adverse effects on biological diversity with a view to avoiding or minimizing such effects. Rumbetti has failed with its responsibility to monitor the development of the project, having conducted an inadequate EIA. The depth of Rumbetti's EIA was insufficient because although the respondent carried an EIA for the first phase of the project, this study was conducted only during the second half of 2015, pointing to its precariousness. Your Excellencies, it is a notorious fact that many bat species have their movement patterns altered through the seasons, and the royal noctule bats especially migrates according to their...
I'm sorry. Let me ask you something. Will the wind farm project not benefit the environment and species in this kind, including bats, by helping Rumbetti fulfill its national commitments related to climate change?
Indeed, Your Excellency, the climate actions from Rumbetti is a valid measure, is a valid issue. But one matter is not, both matters are not mutually exclusive, considering that the respondent could address climate change by including mitigation measures in its wind farm project. And such as, yes.
Exactly that. What mitigation measures could be implemented?
Your Excellency, several mitigation measures could be implemented, such as the increase of the cutting speed, meaning the deactivation of the wind turbines in periods of low wind speed, which has proven to reduce bat mortality by up to 50%. Also,
and if I may step in, have you discussed in your negotiation phase such mitigation measures with the other party? And if so, which were the responses? Because I saw that you exchanged some correspondence and diplomatic letters. Did you think about negotiating it before bringing it to court?
Your Excellency, as the Corfu Channel case stated, in which the ICJ stated, the burden of proof must be taken by the state which has the sovereignty. And such, considering that Rumbetti did not take any steps to further... Yes, Your Excellency.
Sorry to interrupt you, but in which way the Corfu Channel case is similar to this case? Why this court should take the Corfu Channel in consideration?
The Corfu Channel case should be taken into consideration regarding the Article 38, paragraph 1d from the ICJ statute, which infers that judicial decisions should be taken as subsidiary sources for determining the rules of law. And the similarities between the Corfu Channel and our present case can be found in a way that the countries, namely Nicaragua and Costa Rica, were conducting activities which represented harm to one another. But the court has stated that an environmental impact assessment should be made by all states, and these environmental impact assessments should be notified to the other country, to the country likely to be affected, if the EIA demonstrated that there was a significant harm, there was a risk of a significant harm, which Rombetti found in the present case, because the
I'm sorry again, but according to what you just said, I'm thinking that maybe all the environmental assessment that have been made for one of the countries should be sent to the other one in order to be improved. That's what you're saying? All the projects that is developing in one of the countries should be approved by the other one?
No, Your Excellency, but there must be a sense of cooperation between the countries. And as the Corfu Channel stated, when an EIA has demonstrated that there is a risk of significant transboundary harm to happen, the state implementing this measure should and must take notifications to the state likely to be affected.
And if I also may step in again, do you think that the Chiroptera Crusaders, the NGO that have conducted monitoring activities at the wind farm, do you think that the results of such monitoring activities may be considered an environmental assessment that could properly be brought to court?
Indeed, Your Excellency, the monitoring made by the Chiroptera Crusaders represent a relevant and important monitoring to the development. But nonetheless, Rombetti has prohibited the Chiroptera Crusaders to further monitor the wind farm post 2019. So the country has failed with its duty to conduct monitoring activities after the operation has started, interrupting the monitoring procedures being undertaken by an independent conservation group, violating customary law, violating Article 7C of CBD and CMS Resolution 11.27. Also breaching Eurobet's Resolution 8.4 and 8.11. Also having conducted the EIA only prior to the wind construction in operation.
What's the legal significance of Eurobet's Resolution 8.4?
Resolutions, Your Excellencies, should be taken according to Article 31 of the Vienna Convention of Treaties. Resolutions should be taken as subsequent practices of a treaty, as for they represent the will of this treaty. Also, having conducted an EIA only prior to the wind farm's construction.
I'm sorry again, but my last question. I believe El Duque is considered a development economy, but Rombetti instead is a development one. Do you think it's fair for El Duque to try to impose its environmental agenda on Rombetti?
Your Excellency, we submit that the applicant, El Duque, was only trying to protect a species, its a natural resource from its country. Therefore, as the ARTA Article 10 resembles, the mitigate measures, extraterritorial measures can be taken to protect human and animal and life and health. Romberry disregarded the fact that oftentimes acoustic monitoring before construction of a wind farm may not show much bad activity there, but this increases after the facility is built, as Sarah Weaver, a biology lecturer at Texas University, reveals. Undoubtedly, this means that Romberry sought to hide the wind farm damages to the bats population in order not to be held accountable for its wrongful actions. Thirdly, Romberry violated international law by breaching its obligations under CBD, CMS, Eurobats, and ARSWA. May I finish my pleading, Madam President?
You have 30 seconds to conclude your sentence, Agent.
Your Excellencies, to sum up, we would like you to adjudge and declare that Romberry violated international law with respect to its wind farm project. And with that, I conclude my submission, Your Excellencies. If you have any further questions.
Thank you, Agent.
Thank you. It has been an honor arguing before this court.
May I approach the bench?
Please, Agent, do so.
Good morning, Madam President, Your Excellencies, may it please the court. As my co-agent previously said, my name is Jade Leal, and representing the applicant, I will be addressing now the matters of point 2. Alducra complied with international law with respect to straight measures for tapegian products. Well, the first alignment to be made is that the applicant's extraterritorial measures are fully in accordance with the state sovereignty universal principle. The general principle of state sovereignty predicts that the states are responsible to determine their own economic, social, political systems, just as well as their foreign policies. It remains clear that by establishing any restrictions on the export of tapegian to its territory, Alducra did not disrespect in any sphere the sovereignty principle. In fact, quite the opposite, Your Excellencies. Just as Romberry has the right to sovereignty, the applicants must also be entitled to it. Oh, Madam President, Your Excellencies, Alducra's trade measure also works in accordance with the fundamental principle of non-intervention. See, the 2019 statute is not mandatory. It means that Alducra is not forcing any country to adopt the measures that are being proposed. Rather, its trade measures only apply reasonable sanctions over countries that choose not to follow the statute. With that in mind, one can cite the principle of non-intervention, which supports that countries implementing extraterritorial measures cannot force other countries to change its internal policies. Your Excellencies, Alducra did nothing more than grant Romberry the decision to export taxed tapegian or non-taxed tapegian. Moving forward, Alducra did not violate the general most favored nation treatment. Alducra created this in the 2019 statute and directed it to all countries, giving them an equal period of almost 10 months for compliance with the statute's requirements. All things considered, the general most favored... Yes, Your Excellency?
Doesn't the time seem kind of suspicious in this case? Alducra passed the legislation after Romberry refused to make changes in the wind farming project. So is Alducra trying to retaliate it?
No, Your Excellencies. Since the nation tried to find a way to cooperate, and the respondent didn't show a will to do so, the applicant just found a way to make his point and to guarantee that the best for the bats will be happen. So the taxation is not a way to retaliate since it isn't mandatory. So the applicant is not obligating the respondent to follow the rules of the statutes in any way. All things considered, the general most favored nation treatment asserts that a state, when creating importation rules, cannot benefit or harm one country or another, as it is stated in Article 7 of ARTA. Regarding the applicant's conduct, it is evident that there wasn't any discriminations. Also, Your Excellencies, it is important to say that 2019 statute did not violate the national treatment.
Agent, excuse me. Yes. You're saying that there isn't any discrimination in the case at hand, but isn't it true that only applicant and respondent produce the product under discussion here? They gave in order to produce that
Indeed, Your Excellencies, to the moment, the both countries are the only ones in the world that produce the product.
So how come can you say that this is not discriminatory if only both of you produce that product?
Well, Your Excellencies, since the nation is giving a time for the respondent to adapt to the new rules that are being proposed by the statute, as it isn't mandatory, the respondent has a sufficient time to be ready to adopt the statute. So yes, as I said, they have enough time to adopt the statute and to be ready to adopt the statute.
By any chance, are there any precedents under international law that prescribe a certain period of time to be considered enough in order for a country to adapt its products to be exported or either imported to another nation?
I'm sorry, Your Excellency, I'm not able to answer your question. So, as the paragraph 26 of the record specificates, the statute was directed to all farms implementing non-bad safe practice, including Alducra's farms, and the 20% taxation was aimed at the applicants as well. Your Excellency.
I'm sorry. Let me ask you something, please. Didn't Alducra violate ACTA through its commercial measures by favoring its national products?
No, Your Excellency. Since the most favored nation principle says that all countries should have the same equal content, the same equal starting point to do the changes and to adapt to the statute. And since the applicant is guaranteeing that the respondent will have the same this period of time to adapt and to be in the same starting point, to be at the same starting point, it isn't violating anything, actually.
Could you explain this court how the most favored nation principle is binding under international law?
Well, it is a general principle of international law, Your Excellency.
And that's enough?
Well, it is, I wouldn't say it is enough, but I would say it shows the relevance that it takes to discuss, to take it in consideration.
Okay.
Regarding the applicant's conduct, it is evident that there wasn't any discriminations imposed by the applicant. And Your Excellency, it is important to mention that the national treatment principle from Article 8 of ARTA asserts that a state cannot afford protection to its domestic products, and also that there must not be an excess of restrictive measures on foreign products in relation to domestic products. It is absolutely clear that Alducra did not violate the national treatment principle. Also, Your Excellencies, Alducra's trade measures is according to the section of Article 10 of ARTA. The ARTA states that decisions made by the General Agreement on Tariffs and Trade panel and the decisions made by the World Trade Organization appellate body are subsidiary sources of law for interpreting the terms of ARTA. It should be noted that the ARTA resembles the GATT, specifically in the Articles 10 and 20. Therefore, the tuna dolphin case 2 report discusses the exceptions to the no-intervention advocated in paragraph B of Article 20 of GATT, which asserts that parties in the convention may not be hindered from adopting and enforcing measures necessary to protect human, animal, or plant life or health. The opinion was clear and even asserted that the aforementioned mention in paragraph B does not require in this text the protected animals to be located within the jurisdiction of the country implementing the measure at stake. Hence, it is true and legitimate that Alducra seeks to protect bats which may be located in the territory of Romberi. In addition to all of that, Alducra's trade measures also conform to the exception of paragraph G of Article 10 of ARTA, which allows infractions to the agreement when the measures are relating to the conservation of accessible natural resources. It becomes notorious, Your Excellencies, that the animals that Alducra aim to protect with the trade measures are accessible resources. Once a species is listed as vulnerable according to the IUCN Red List, and as...
Excuse me, can you please tell me if your state is actually complying with the chapeau prescribed under Article 10 of the ARTA agreement, please?
I'm sorry, can you please repeat your question, Your Excellencies?
Can you please tell me how you are addressing Article 10 of the agreement between the parties, if in the chapeau of the argument of the Article 10, it is prescribed that indeed no measures shall be taken in order to create a retaliatory discrimination to another product. So how come are you addressing Article 10 in this case?
Well, Your Excellency, as I previously said, the Article 20 of GATT says parties in the convention may not be hindered from adopting and enforcing measures necessary to protect human, animal, or plant life or health. Well, since the applicant is proposing a way to guarantee the protection of the bats, they are going with these measures is according to the Article 10 of ARTA.
Just because Article 10 of ARTA is similar to Article 20 of the GATT, shall we apply either way, both treaties?
No, I'm sorry. And regarding the Article 10 specifically, the paragraph G of Article 10 of ARTA allows infractions to the agreement when the measures are relating to the conservation of accessible natural resources. And as I was saying, the animals, the bats are listed on the IUCN Red List and even in appendices of CITES, CMS, and Eurobats. So the bats can be considered accessible natural resources. So as the paragraph G states, ARTA allows infractions to the agreements when the measures are relating to the conservation of those animals. It is also important to invoke the World Trade Organization appellate body report in the tuna shrimp case that understands that paragraph G must comprise a notion of sufficient nexus. In resume, sufficient nexus constitutes two conditions: a proportionality between the purpose of conserving the exhaustible resources and the policy applied in the concrete cases necessary. Your Excellencies, the applicant's trade measures are reasonably related to the policy goal of conserving the bats, because the conversion of non-bat safe agave production to a bat safe agave production has already been proved by scientific analysis to mitigate risks for the bats. And secondly, the sufficient nexus urges for an exploitability of the species, meaning the state's practice of preserving it. ODUCRA has preserved the bats, considering the statute of 2015, implementing domestically enactments prohibiting non-bat safe agave practices in the applicant's territory. ODUCRA complied with both conditions, having acted with a sufficient nexus in the present case. Your Excellencies, ODUCRA's trade measures comply with the chapeau of Article 10 of ARTA. As outlined by the thorough shrimp case, a trade regulation not to be classified as an arbitrary or unjustifiable discrimination shall obey two criteria: proportional deadlines for the transitional periods and compliance with the principle of balancing of rights. Therefore, this principle comprises the notion of causal connection, least restriction, and no disproportionality, all of which ODUCRA has complied with, especially because its trade measures have connections with the scope covering the exceptions of ARTA. Furthermore, the applicant exercised the least restriction in imposing mere incentives to Rumberi in the form of taxation, when it could easily have been the exportation of non-bat safe taxation to its territory, which will be a retaliative manner. With all of that being said, me and my fellow co-agent would like to adjourn and declare. May I finish my pleadings?
You have 10 seconds just to conclude the sentence, okay, agent?
Thank you. My fellow co-agent and I would like to adjourn and declare that Rumberi's wind farm project violated international law, and ODUCRA's measures for taxation products did not violate international law. Therefore, if there are no further questions, I finish my pleadings and make this the court.
Thank you, agent.
Congratulations, Team A. Team B, when you start, I will start the clock.
Okay, I'm starting. Good morning, Madam President, Vice President, and members of the court. My name is Liara, and my co-agent Beatriz Montenegro and I are here in the presentation of the Republic of Rumberi. Our oral arguments shall consist in two different steps. Primarily, I'm going to present the arguments to prove that the Republic of Rumberi did not violate international law with respect to its wind farm project. Furthermore, my co-agent will present the arguments to demonstrate that actually the federal states of ODUCRA violated international trade law with
Excuse
respect.
me.
Oh, okay.
Could you speak a little bit louder, please?
Louder? Okay.
Yes.
Yeah, excellent.
Thank you.
The federal state, is that okay? You can listen to me, okay?
Better.
Okay, thank you. The federal states of Aducra violated international law with respect to its measure for tapagium products. Aducra's accusations relies on the operation of a multi-phase wind farm project, a project made by Rumberi to meet commitments under its national determined contribution to the Paris Agreement. The project was consciously chosen to be phased, following the precautionary principle, in order to analyze the impact on the environment, and only after conducted and reviewing an EAA, the first phase was finally approved.
Aisha, what is the legal status of the precautionary principle?
The precautionary principle is recognized in international customary law, and this court decided about it in the Pulp Mills case, in the Costa Rica versus Nicaragua case, and in the nuclear test case, the France against Australia. So it's customary law, international law. It's binding, but it must be analyzed in case by case.
Agent, excuse me, you just quoted 3 cases where you said, I'm not sure if I understood it properly. You said this court applied that principle?
Analyze that principle in each case.
But didn't it reject in all of those cases the application of that principle? So how come would this be a customary international law?
In the nuclear test case, it didn't reject the precautionary principle. And in Nicaragua versus Costa Rica and the Pulp Mills, it established standards of when it is applied and when it's not.
But in the nuclear tests, did we have the merits of the case? Did this court address the merits of the case?
Sorry, I didn't understand it.
In the nuclear test case, did this court end up analyzing the merits of the case?
It analyzed that in dealing with the precautionary principle, harmful activities must be avoided, even with the lack of scientific data, but only acting in proportional and case by case. Again, the court always established that it must be analyzed case by case. May I proceed?
Yes, please.
Okay, I'm going to enumerate our oral arguments. First, Rumberi did not cause a transboundary harm, as there is no causal link proved between the wind farm operation and the bad depth situations. Second, even if there could be found a causal link between the wind farm and the bad depths, the level of damage was insignificant. Third, there was no violation of any convention that this country is signatory. Fourth, Rumberi acts in accordance with several environmental conventions, delivering efforts to sustainable development through a sovereign and legitimate energy matrix transition. I'm starting with point 1 that states that Rumberi did not cause a transboundary harm. In the landmark decision.
Yeah, excuse me. Rumberi provided government subsidies for the wind farm project and also allowed its operation. And actually, you are claiming its climate benefits as part of its nationally determined contributions. Doesn't that make Rumberi responsible for killing the bats?
Yes, Your Honor, I'm actually going to address your question during my point now. That proves that Aducra did not issue any data to its accusation. And in the Costa Rica versus Nicaragua and in the Pulp Mills case, this court decided that to issue an accusation of transboundary harm, it must be proved that there was a significant change in the country's own environmental. The bad found that near the turbines only in Rumberi territory does not constitute a transboundary harm, as Aducra did not issue any data to prove a significant change on its own environment.
But Asia,
sorry.
Okay.
You can proceed, Roberto.
Thank you, Judge Barbara. Considering that Humbeti is alleging compliance with customary law, does the transbordering harm principle is considered general practice accepted as law? And if possible, and if positive, could you give us some examples of state practice?
I'm sorry, Your Honor, your audio was cutting in some steps. Would you please repeat your question?
Yes. Since Rumbeti is alleging compliance with customary law and is bringing to court the principle of transboundary harm, do you think it is considered general practice accepted as law, such principle? And if positive, if the answer is positive, could you bring us some state practice examples of such?
Okay, transboundary harm is not a principle in the environmental international law. It is actually something that can be issued to the courts. The principle are due diligence with the persification in the EIA that Rumbeti did. And even though Rumbeti did the EIA, it's not a requirement of overall, only on the cases that it's found that is likely to cause a transboundary harm. And this court again decided that it should be decided case by case. There are not an overall rule that states that all states must conduct an EIA. And even though Rumbeti did conduct it in good faith, and after even allowing an NGO to operate in the area to monitor the bats.
Okay.
But isn't it true, Agent, that you canceled the possibility of the NGO to continue carry out its job as a surveillance to or monitoring to the whole project as a continuance to what it has been doing so?
Yes, Your Honor. I must remember that Rumbeti is a developing country, that there is a historical practice of the developed world to impose its own environmental agenda to the developing world, regardless its economic possibilities. In this sense, Rumbeti found that the NGO was not acting in their best intentions, instantly Aducra's reaction from against Rumbeti's sovereign, what was further confirmed by Aducra's demand to the wind farm shut down.
But then aren't you violating the due diligence that you just mentioned?
No, I'm not violating the due diligence principle because Rumbeti has its own environmental sovereign bodies, which carry out the working of monitoring the area and the flora and fauna with excellence. So the wind drop of...
Excuse me, Agent, I'm sorry to interrupt you again, but then the applicant stated that the idea of the transboundary harm was not that the bats were found dead within its territory, but in fact that the bats are utilized to pollinize and to other ideas on activities on producing the agave. So how come would this not be a transboundary harm? Not only because the bats are dead indeed, but because of their importance to the agave industry. Isn't that a transboundary harm?
Okay, Your Honor, I will present some numbers of wind farms and bats and the overall in the world to be a comparison with our situation in Rumbeti. In a 2-year period, only less than 1,000, actually less than 600 bats were found dead via the turbines. While this was happening in Rumbeti, 200,000 bats are found dead per year in the wind farms near Germany, 600,000 in the United States, and 80 in the United Kingdom. Even with these numbers, the operation of those wind farms was not contested. And even with these numbers, the main cause of bad deaths are actually in those countries, human activity, collision with buildings, and wild or domesticated predators. So it's not reasonable to consider as first option that first, the level of damage was significant because in comparison with other wind farm operations, the number is stricken. And second, it is not reasonable to consider as first option that the bats found that got killed actually by the turbines, because as I presented, there are many other activities and that could cause bad deaths. May I proceed?
Please do so.
I must also remember, Your Honor, again now that Rumberi project is internationally determined contributions to be made to the Paris Agreement. And despite its non-obligatory nature, political sanctions are to be expected against parties which do not follow through. This because NDCs are a crucial step in securing a better environment for all, and following the first one priority of UNFCCC, the well-being of humanity. Through this angle, they share of renewable energy sources. Okay.
Let me ask you one more thing, please. Regarding eco-labels, shouldn't people have the right to know if the products they buy can have negative effects on the environment or to species such as the bats?
Yes, Your Honor, you're right, they should. I believe that ADUCRA failed in this particular issue when it addressed that all the labeling should be produced by Rumberi, and that states that Rumberi should all the financial resources that is needed to produce the label should be taken by Rumberi. And again, must remember, Your Honor, that Rumberi is a developing country with limited resources and has also other priorities to, and even now we are in a trouble with the COVID pandemic, we have even more problems to address.
So can we use the excuse of being a developing country to actually implement rules or regulations that are not totally green under international law and affect indeed the rights of other states?
No, Your Honor, Your Excellency, we can't. But I must recall, Your Honor, the CBD itself and its preambular, and I must recall, Your Honor, that the preambular is the guidelines of the whole treaty. It states that, quote, economic and social development and poverty eradication are the first and overriding priority of developing countries' party. What Rumberi did was following the preambular of CBD and trying to find a way to conciliate its few resources with multiple intents. It's so development, poverty eradication, climate change, and sovereign on its own energy sources.
Do you think that the principle of common but differentiated responsibilities could apply to the case?
Yes, Your Honor. I think it's very important, this principle and the special circumstances given by developing countries. They are both important to stress. And the UNFCCC Rio 92 recognizes in Article 3.5, and also Rio Plus 20 and many other conventions taking into account those principles, because there is just a differentiation of resources available to each country. It is not reasonable to demand that all countries must act in the same way.
Thank you.
It's also important to emphasize that this issue deals with a fundamental pillar of international law, which is sovereign. In this sense, CBD in Article 3 recognizes that countries have the sovereign right to explore their accordance. May I finish my speech, Madam President?
You have another 30 seconds as I gave the applicant the same time.
Okay. In this sense, the preambular of CBD in its Article 3 recognizes that countries have sovereign right to explore their resources in accordance with their own environmental policies. For all exposed, we ask the court to allow Rombetti to continue the operation on its wind farm project, making its best efforts to find climate change with the minimal environmental impact while developing its internal energy market and fighting poverty. Thank you.
Thank you, Agent. Now the second respondent can address the floor.
Madam President, Your Excellencies, I hope you can hear me. Good morning, may I please the court. My name is Maria Beatriz Montenegro, and I'm speaking on behalf of the Republic of Rombetti, now calling your attention to the second issue, which relates to Adocra's violation of international law and regional law regarding its recent trade measures. And Your Excellencies, I will be presenting major arguments that can be summed up in 3 points to evidence that Adocra does not entitle the recognition of this court. These arguments are: 1, Adocra violates the aims and values of the ACTA, as well as international law. 2, the measures are insufficient to evoke the agreement's exceptions. And 3, the measures are unlawful for violating the requirements of the chapeau of Article 10, found in the ACTA. Now, first, by establishing these measures, Adocra does violate the very scope and aim of the ACTA, which is directed to the reduction of tariffs and to the increase of opportunities and market access, as it puts in its preamble. Not to mention that the overall international bodies of commerce and macroeconomists themselves recognize that tariffs should be used only as a last resource due to the great level of impact that they have on other countries' capacities for development. But the applicant also violates the principle of national treatment, which prohibits unequal treatment between like domestic and foreign products. Now, this principle deals not only with official discrimination put into law, but also with a de facto discrimination. And this factual discrimination, yes, Your Honor?
As the applicant has stated, it gave considering time for the respondent to adjust its rules in regard to the products and the labeling, etc. Yes. Don't you consider that time to be enough, or do you still consider that to be discriminatory?
The fact that there exists a time does not suffice for the paragraphs. It relates to, in fact, the chapeau. And when we discuss if a measure is, in fact, discriminatory in an unlawful or arbitrary way, we must look into many criteria, such as the flexibility of this measure. And in this case, Adocra establishes that the same measures should be applied, or those that have the same effects. But when we look into the issue as a whole, we will see that Adocra is imposing measures that, using its abusing of the vulnerability of the other party, it's in fact coercing Rombetti, because even if the applicant says the measures are not mandatory, Rombetti is put between a situation that it will face either these measures, either the significant economic loss that it has. And when we look into the period of time of adaptation, we will see that Adocra completely violates the principle of special treatment of developing countries, because it puts the same time period to all other nations. But, Your Honors, when Adocra puts the text of the statute to all other nations, it is in fact a decoy, because the only other producer and seller of tapajum is Rombetti, making Rombetti the only competitor for Adocra in this specific economic area. This means that it was in fact retaliatory, because it only happens after the diplomatic altercation between the countries, and it is in fact being used to violate fair trade. And by doing so, the fact that there is a adaptation period does not mean that it is sufficient to justify that Adocra is entitled to the recognition of the exceptions found in the Article 10 of ACTA, neither its chapeau, neither its items. Yes, my Honor, Madam President.
I just have a question. Do you have any basis for stating that giving this time, a period of time would be enough, or this period of time is not to be taken into consideration? Are there any precedents, for instance, from the WTO panels that could mention that?
Yes, in fact, in the US shrimp turtle case, the United States have imposed the same period to all countries without taking into consideration their own economic capacities and infrastructural utilities and their own ways of dealing with the measure. But in this case, in our case, we will see that the time of 9 months put to allegedly all of the countries is in fact shorter than the time that was necessary for Aducra's own farmers of a developed nation, to all come into adequacy and conformity with the same requirements. So the time period that is put is shorter, and it's put towards directly and in a retaliatory manner and arbitrary manner to a developing nation that does not have the same resources of a developed one.
But then shouldn't we take into consideration that that rule is also applicable to their own state? I mean, it's not only for foreign products, it also applies for domestic products. And yes, if I'm not mistaken, that's different from the shrimp turtle case.
When we look into the principle of national treatment, Joanna, which I believe is exactly what you are referring to, we will see that this principle prohibits discrimination between like foreign and domestic products. But when it tackles discrimination, it is understood throughout the case law of the WTO, not only as the discrimination that is put in text in the law of the country, but also as a de facto one. Because even if Aducra says that the same measures goes to all tapageon, either domestically produced, either imported from other countries, therefore supposedly not discriminating based on nationality, we will see that a discrimination de facto happens because it creates an inequality of opportunity inside Aducra's markets between the products of Aducra and Rumbeti, which is its only competitor. Therefore, Aducra tapageon is already considered friendly. All of Aducra tapageon is considered friendly, making Rumbeti the only one to face the negative conditions, the negative conditions that will derive from these measures. This helps to show how the measures are being used as a protectionist tool, directly favoring its national producers to a factual discrimination that is also retaliation. But not only that, Your Honors, Aducra disrespects and violates the biggest pillar of international law, one of the biggest, by attempting to introduce in Rumbeti's national sovereignty and its own regulatory autonomy. Because the WTO jurisprudence has continuously affirmed, in fact, in the US Tuna 2 GATT case, which was evoked by the applicant, the WTO affirmed that one cannot use trade relations to enforce its own domestic laws in another country, even if it is to protect animal health. And even if the measures...
Yeah. So sorry if I may step in. And considering the critics of the WTO appellate body on the, going back again to the shrimp turtle case, considering the critics from the appellate body on the failure of the United States to promote and engage in cross-board negotiations, do you think Aducra also proceeded as the same and has a failure in such promotion and engagement occurred?
Could you please repeat the question if I misunderstood?
Okay. Based on the critics of the appellate body, of the WTO appellate body, on the failure of the United States to properly engage and promote across the board negotiations, so the rules of the environmental protections of Aducra could also be imposed in Rumbeti territory. Do you think Aducra also failed to engage in proper negotiations? Do you think any alternative solution could be proposed to this case?
Yes, Your Honor. In fact, regarding the efforts that the applicant took between March and May of 2019, those efforts should not qualify for deploying their own reasonable efforts at the time in order to achieve a mutual understanding, because those were taken amidst a situation that was already sour. It was not friendly because the countries were exchanging letters because one country was demanding the shutdown of an operation that was providing a lot of jobs and a lot of benefits to a developing nation. And in this sense, for the applicants to justify its own measures in the sense that it had no other alternatives to be taken is in fact not true, because when the WTO itself recognized that the necessity of a measure, if Aducra is evoking item B of Article 10 of ARTA, it states that the measures must be necessary. And one of the issues to qualify the measure as necessary is if it was the only least harmful tool possible. And this was hardly the case, because Aducra's unilateral impositions were not less resources, and actually many international environmental treaties advise against unilateral measures, such as Principle 12 of the Rio Declaration, that reads that, quote, unilateral actions to deal with environmental challenges outside the jurisdiction of the importing nation should be avoided. ADOCRA has failed to demonstrate that other least harmful measures were not available to it at the time. And beyond that, in the WTO case between the European communities and asbestos, the judges have framed a necessary measure as the one able to reach the goal only any other one could. And ADOCRA has never shown this to be the case. Does that suffice your question, Your Honor?
Thank you. Yes.
Right. So a great argument relates to how ADOCRA is unable to evoke Article 10 and its paragraph. Besides the situation of necessity, when there was no other alternative available, necessity only happens again if the contribution is sufficient to achieve its own objectives. And in this case, there is no reliable evidence that confirms that ADOCRA's measures do secure the level of environmental protection that it desires, because there has been no information about the results of these new practices, even outside ADOCRA. But when we look, in fact, into the chapeau of Article 10, even if a measure is justified under its items, the chapeau should also be taken into consideration, because it says that it prohibits a measure that is discriminatory, arbitrarily, or unjustifiably. And the WTO says that these such measures can be found to be unjustifiably or arbitrarily discriminatory when they are inflexible, such as it is the case with ADOCRA, because it requires the same and puts its own view of what protection for bats should be and what constitutes a violation of environmental protection. It is imposing in another country, abusing its own vulnerability, and the fact that its exportation goes majorly or majorly to ADOCRA. And also, again, by not giving any structural support, ADOCRA goes against the principle of a special and differentiated treatment to developing countries. It violates the Artis Preamble, which establishes that we need to consider also the respective needs and different levels of economic developments. So this eco-imperialist position by ADOCRA is also not a surprise, because it's a well-known practice used by developed nations to impose its own agenda against the least developing world, claiming an environmental goal. And I believe, Your Honors, also that the way that ADOCRA is doing things, therefore, putting this statute 5 years after the 2015 statute has already been in practice, and throughout those 5 years, the relationships between ADOCRA and Rumbeti have remained the same in a trade sense. Only now, after the altercation and diplomatic confusion between the countries, has ADOCRA imposed these measures to farmers of other nations, not its own. And the way that it does, the way that it writes down in the statute that the measures goes to all other countries, is in fact a decoy that it's using to deny the fact that it's targeting directly its own competitor regarding tapagium products. And in case, when it comes to item G of Article 10 of the ARTA, it said relating to the conservation of exhaustible resources, and as the applicant has already argued, there must be a sufficient link between those, and ADOCRA has no credibility to demand that other nations adopt this specific program when the applicant itself fails to give any evidence of their efficacy. ADOCRA's measures do not stem exclusively from a legitimate regulatory policy, as was required in the WTO case of US Tuna 2 against Mexico. And as evidence in previous expositions, ADOCRA's actions are directed not anymore to its domestic farmers, but only to its sole competitor, therefore conceding a converted advantages to its own farmers.
Excuse me, you mentioned shrimp turtle, tuna dolphin. Is this court bound to follow the decisions of the WTO?
The International Court of Justice is not bound to follow the decisions of the WTO, in fact, but when we're dealing with this case, that the treaty between the parties explicitly recognizes that the decisions, interpretations, and developments of the case law of the WTO can be used as a subsidiary base for applying its own decisions. This should be taken into consideration. Not only to mention that the WTO is in fact the biggest trade body there is in the world, meaning that the entirety of the multilateral trade system goes to it in order to search for interpretation, values, and decisions and its own development. So yes, Your Honor, I believe that the respondent suffices that the WTO should be taken into consideration. And for all that has been extensively discussed, there is no doubt that adopted measures do not fulfill the exceptions requirements and violates the agreement itself, as well as duties and principles under international law. If you honest have no further questions, I would yield my time. It has been a pleasure. Thank you.
Congratulations, both teams. Applicant, do you want the rebuttal? You may start.
Thank you. The respondent, may it please the court firstly, the respondent mentioned that there was no significant damage in the present case. But as we can see, Your Excellencies, bat fatalities itself, it's a significant damage, not to mention all the biodiversity and ecological detrimental effects which are comprised of the bat mortality, such as insect control, such as plant pollination, and also, indeed, states have their state sovereignty, as the respondent mentioned. Nevertheless, the sovereignty state principle cannot use its territory to impose detrimental effects to the environment of the other state. Therefore, the transboundary harm caused by the respondent does not suffice for liability for the alleged principle of sovereignty. And also, the argument that the respondent brought, considering the bat fatalities in the world, the numbers that the respondent brought of hundreds of thousands of bats being killed by wind turbines, and these numbers only helps strengthen the argument that the wind farm from the respondent was the cause that made the bats to die. And the duty to cooperate, Your Excellencies. Thank you. May it please the court.
Congratulations, both teams. I now officially end this round, and I will leave the judges to the separate room. Thank you. Congratulations.
Thank you. Congratulations to all of you.
Thank you, guys.
Good luck.
Congratulations.
Vou encaminhar os senhores juízes para uma sala separada, para que vocês possam deliberar, conforme as instruções de Mariana, e depois eu trago vocês de volta para dar o feedback às equipes. Não precisa fazer nada que será levado automaticamente. Equipes, falta só Bárbara ser transferida. Pronto, foi agora. Pronto. Mais uma rodada terminada. Primeira rodada da equipe 3. E aí, o que vocês acharam?
Foi massa. Estou suando aqui nesse momento.
Eu também. A gente que é do Nordeste, né? Nesse calor de terno, fica uma dificuldade.
Pois é. Okay,
já liguei o ar-condicionado aqui, velho.
Ficar de roupa completa assim, realmente é complicado. Agora eu vou te dizer que geralmente abril lá na estética, não vai ser o caso desse ano, né? Mas geralmente quando são lá as competições, tem um sol pesado. E aí lá são vários campos, então vários blocos, você tem que se deslocar andando ali no sol terno, todo completo. Não é o frio que se imagina nos Estados Unidos, não.
Eu imagino.
Inclusive, a época quase sempre coincide com a época de Spring Break lá dos Estados Unidos. Então, é época de praia e a cidade lota a cidade vizinha, que é São Petersburgo, lota de universitário indo para lá por causa da praia. Então, é um período quente para eles.
Vai ser em abril, afinal, mesmo com...
Eu tô na dúvida aqui quando é que é. Deixa eu dar uma olhada. Março, 25 a 27 de março, isso. Online, dessa vez.
Ok.
Uma pena que vocês não vão poder conhecer a Stetson presencialmente, né? Mas Stetson realmente é fenomenal para multicorte, porque eles têm todo o curso de graduação voltado para prática de foro, né? Prática advocatícia. E aí eles têm lá estrutura enorme física, são 8 salas, simulando aquelas cortes lindas que você vê na televisão americana. E é bem interessante. E os juízes também, que eles convidam, os que são os professores da faculdade, são muitíssimo preparados para tudo isso. Mas quem sabe ano que vem, se tudo der certo, já vai estar tudo voltando ao normal.
Tem todo ano, né, a competição?
Tem todo ano. Essa é a 25ª edição da competição. O pessoal da equipe 3, vocês conseguiram depois tranquilamente fazer funcionar microfone e câmera? Não teve problema durante a rodada não, né?
Não, demorou um pouquinho para conseguir, mas deu certo. Tive que ligar e desligar 3 vezes o computador, mas...
Você conseguiu pelo computador mesmo depois?
Sim, pelo computador agora.
Entendi, ótimo. Realmente a visualização fica melhor para ver as outras equipes e os juízes.
Aí, logo na primeira deu aquele frio na barriga. Deu certo. Rui, posso aproveitar para fazer uma pergunta sobre a competição em si, né?
Claro.
A gente ficou na dúvida sobre o resultado, de fato, quem iria para a final, porque como é um dia depois, para a gente se organizar, sabe? Tem gente que está viajando. Aí, vocês têm uma previsão?
Quando vai sair o resultado? Você pergunta?
Quem vai para a final? Isso se sairia já hoje? Acho que sim, né?
A última rodada hoje é 7 horas, né? Então acabaria por volta de 8h30. Se não houver empate no critério de vitórias, né? A priori seria rápido. É só fazer uma verificação geral, verificar se as somas, cálculos foram feitos corretamente. Se tiver empate, a gente tem que fazer os cálculos de desempate. Assim, eu espero que, independentemente, dê tempo de dizer o resultado hoje. Até 10 horas e tal. Para que vocês possam se programar. Agora, como é informatizado, né? Que os juízes enviam pelo formulário a nota e calculam em tese automaticamente, pode ser que já dê para dar o resultado hoje. O resultado dessa rodada, a priori, eu vou informar aqui, daqui a pouquinho. Assim que os juízes terminarem ali, eu vou verificar se foi tudo enviado corretamente e depois eu já digo o resultado. Para ser rápido. Porque, assim, eu tô falando isso que foi uma facilidade porque é informatizado, né? Mas a Stetson, por tradição, eles, mesmo sendo presencialmente notas em papel, eles trazem o resultado ainda durante a rodada. O bailiff da sala pega os papéis dos juízes, leva para a central, onde tem os alunos dedicados a isso, calculam e trazem o resultado de volta. É realmente impressionante. Sem tecnologia, feita na mão mesmo ali. E aí aí eu fico comparando, quando é um bloco distante em que tá a sala, aí o bailiff tem que andar o campus inteiro para ir lá buscar a nota, voltar. Mas realmente ajuda para vocês já terem noção do quanto vocês vão avançando as rodadas, ao invés de esperar até o final para descobrir como é que foram, né? E também agora...
É um ponto muito positivo, de verdade.
E também para ver...
Desculpa,
diga.
pode falar, Rui.
Nada, diga.
Vai ter algum feedback? Acho que você disse que a gente recebeu feedback do juiz.
Sim. Assim que eles terminarem de avaliar, a Mariana vai me informar aqui, eu vou fechar a sala e eles vão voltar para cá para dar feedback a vocês.
Entendi. Ok.
Porque essa é a principal parte, né? A parte onde vocês podem realmente consolidar o aprendizado, saber o que foi bom, o que foi ruim. E aí, sem esse feedback, realmente é complicado. Vocês têm acesso às notas também, que a gente faz disso, de vocês terem acesso à nota logo depois, pelo site, por critério e tal, que já ajuda a ir melhorando durante as rodadas, mas nada se compara ao feedback, né? Nenhum número vai poder explicar exatamente o que o juiz achou.
E a gente achou muito positivo também o fato de que são vários avaliadores, porque a gente deu uma pesquisada e viu que em algumas fases, alguns outros países, era bem possível de terem poucos, então a gente ficou meio apreensiva. quanto a isso. Até mesmo pensando, como somos poucas equipes, até iria cansar os avaliadores se fossem poucos, né? Que são todas rodadas. Aí a gente ficou muito, muito feliz quando vimos que tem uma variedade enorme.
Temos vários avaliadores, acho que são quase 30. Só repete nas próximas 2 rodadas. Acho que são as únicas rodadas em que há repetição. Que são 2 seguidas e são os mesmos. Fora isso, cada rodada tem avaliadores novos, em média 3 ou 4 avaliadores. E incríveis, né? Não sei se vocês já pesquisaram.
Além disso, muito conceituado. Foi, nem comentários.
Foi a equipe do Instituto, pessoas que organizaram essa parte e fizeram excelente pesquisa. E foi ótimo, porque a gente conseguiu abrir portas. Assim, nos últimos anos foi feito aqui em Salvador, né? E, assim, tem diversos profissionais incríveis aqui, mas você não consegue ter uma quantidade suficiente para a competição inteira, para estar toda hora tendo variedade. Agora, quando a gente passou a fazer online, não teve limites mais, né? A gente convidou do Brasil inteiro, tem estrangeiros também, na próxima vai ter estrangeiro. Essa acho que é uma das únicas que não tem juiz estrangeiro. Mas vocês vão ter a oportunidade. Ok, já estão acabando aqui, estão me informando.
Rui, só uma dúvida, outra dúvida, desculpa.
Diga, claro.
Na final, vai ter um Rumberi e uma Ducra, né? Qual seria o parâmetro para, tipo, decidir quem vai ser o Rumberi e quem vai ser o Ducra? Eu não entendi muito bem.
O parâmetro é, via de regra, sempre é quem está com o maior número de vitórias, que é quem está com o melhor resultado prévio. Depois vou dar uma verificada, mas, salvo engano, é isso. Quem tiver o maior número de vitórias das 2 equipes que estiverem na final é que vai poder escolher o lado.
Entendi.
E se tiver empate, vai para os critérios de desempate.
Entendi.
Começaram a chegar as avaliações.
Já está disponível para a gente também? Ou só para você?
Não, ainda não, porque ainda não chegaram todos os juízes. Aí só para mim, por enquanto. Porque lá no site vocês veem a média para cada critério dos juízes, né? Vocês não veem individualmente pelos juízes, você vê a nota final.
Que agora no caso não o nosso, né? Da passada.
Diga, não entendi, perdão.
Eu acho que já entrou no site, tá aqui o resultado. Eu acho que é o nosso, 11 horas, é isso mesmo. Não, é 2 contra 3, isso.
Se estiver, por enquanto, ele não é o resultado oficial.
Certo.
Porque...
Vou guardar.
Não, ele provavelmente está dizendo aí a equipe, isso aí eu acho que é por causa de um bug na programação. Ele, quando não tem resultado divulgado, ele diz qualquer uma das equipes. Ele não diz qual é a equipe efetivamente ganhadora. Deixa eu ver como é que tá aqui.
Você é criador de app, Rui?
Sim, me diverti com isso na pandemia.
Rapaz, velho, que massa.
Tá aparecendo o que lá agora? Tá aparecendo empate no resultado? Isso. Provavelmente porque das notas enviadas até agora daria empate.
E some também. Aparece empate por um momento e desaparece esse texto específico. Então, realmente está atualizando.
Tá atualizando. Agora sim, só para relembrar vocês, a regra de empate é a seguinte. Se a diferença entre a pontuação das 2 equipes de 100 for igual ou menor a 3 pontos, considera-se empate, exceto se qualquer uma das equipes tiver nota inferior a 85. Ou seja, se as equipes tiverem 85 para cima e tiver essa pequena diferença, a gente considera empate. Se for menor que 85 e tiver essa diferença, não é empate. Considera o critério normal. Quem tiver maior pontuação, ganha. Certo?
Tá.
Aí, quando chegarem todas as avaliações, eu informo aqui certinho para vocês o resultado. Espera aí que estão me chamando aqui para a sala de lá. Eu vou lá ver. Estão precisando de mim. Qualquer coisa eu volto aqui. Pronto, acho que todos já foram transferidos. Deixa eu só verificar. Parece que sim. Ah, faltou Bárbara, tá chegando aqui agora. Pronto. Pessoal, então, os juízes já deliberaram. Daqui a pouco eu vou anunciar o resultado, mas antes vou passar para eles darem um feedback deles. E em nome de todo o Instituto, a gente agradece a todos vocês pela presença e pela participação na competição. Tatiana, pode então dar início.
So, I'm speaking in English, right? Even though there are no international judges, I think we should keep on how we would proceed in a normal round. I would say this was a very interesting round. I would highlight some pointers. I mentioned before in the first round that if there are cases, we should always tell the cases, right? Do not wait for the judges to ask you about the case or concerning a case. Just insert the jurisprudence within your arguments. That would make your argument better, and you would avoid the questions from the judges, which is a good thing. Because then we are about to ask a question and then you come with the answer before. So this is a really nice. So this would be something that I would highlight. Another thing that I would like to say that you guys structure very nice your arguments. You make it clear the structure on how you're gonna be exposing your argument. I would just highlight maybe when you answer the questions from the judges, if you can, if you know how, if you think for just a second, and if you do that, okay, I will divide my answer in X parts or in 2 parts. It gives you like some points with the judges, because it gives you like, it shows you're organized with your answer and you know how you're going to expose the argument for the judges. So for instance, sometimes there were 2 questions in one. So you could have given, okay, I'm going to address this question or in 2 parts, and then you give the answers to the judges. So this would be something I would highlight. But overall, I thought this was a very interesting round. Many questions, hot bench. So this is good for you to be prepared to move on the competition. And I guess these are my highlights. Thank you, guys. I don't know who wanna go. Barbara, you had some points you wanted to highlight too, right?
Yes. So I will go straight to the points that Tatiana, that President Tatiana did not mention. But first of all, congratulations. All of you had done a great job. And the first thing that I will point is that some points in your posture before the court. So keep in mind that we can see you even though it is online moot court. So when you finish your presentation and the other agents are presenting their pleadings, you should be paying attention and not doing anything else, because we can see from here. So it's important to do similar that you will do in the presidential way. So this is the first point. The other one, I think that you should try to have a background that do not distract us from your pleadings. So a clean one that cannot distract us with another things. So and to finish, I think you should start to have fun with this competition. So try not to be really nervous. I know it's really difficult, but it's a moment to have fun and to you put a lot of hard work to do your pleadings today and to be here participating on this good court. So search to have fun and to enjoy the moment because you are doing a great job. I think it's all.
If I may, well, congratulations again. In a pandemic year, you took time to prepare yourselves to engage in a different activities that you certainly will bring benefits for your career, for your curriculum. And I think what Judge Barbara said is really important. Have fun and appropriate yourselves from this moment. And you are learning, and I think all of you have succeeded in the task. And we had a great panel, good arguments. Maybe when putting your arguments, being a little bit more relaxed. I know it's difficult. It takes time and years to be like having fun in all your activities and trying to don't stay stuck, and try to put some movement in your arguments and being a little bit more relaxed. Then you can make a better approach or a better connection with the judge, because we are here at the other side of the screen, but paying attention and also enjoying the moment and taking a little time. Just 1 hour and a half, but I know how many hours and how much effort you have put in this 1 hour and a half. So thank you for participating, and good luck for the next rounds.
Great. Hi guys. So first of all, I like to apologize for the number of my questions. I know it's harsh to try to address all of them, but I really believe that it's important for you to move on during the competition. And for the questions, it's important to try to understand the question, try to address it, and come back to your point. So, and for that, it needs time to practice. I know it's hard, as my colleagues had said, but try to realize that no better than yourselves, you know the problem, the issue better than us, for sure. You studied the issue much more than the judges. So important to understand really bad the points and the issues related to the case, and demonstrate how comfortable you are with this question. So the posture, it's quite important to address to the court. So it's not only important to say the right things, but how to say it. So emphasize the questions and the points that you have to, you want to highlight. So it's important to convince them. If I also point one thing that I already said, so I think it's hard to speak in another language, and we want to speak correct, with no mistakes. I really understand that. However, if you read, you will not convince the judge. So try to not do. Sometimes I think could be easier if you have some points that you can go every time you have any doubt, but try to not, even though you make some mistake, it's not a big deal. The most important thing is to address the main points of your case and try to think of all the questions that could be addressed in order to prepare yourself for them. That's what I like to say. And for the end, I really want to congratulate you guys and wish you all the luck and the best through the competition. Thank you.
All right, thank you, judges, so much. So now we're going to do two things. First, we're going to take a virtual picture of all of us to register this. So if I could have everyone at the count of 3, smile, please. 3, 2, and 1. Okay, I got a picture. And now
you didn't tell me before. I didn't get perfumed, so.
Okay, I'll be sending that to everyone later. And now let me announce the result. So I'm going to tell you who won the best memorial in comparison between the teams. The best memorial would be team 2502. Congratulations. And the winning team of the round, mixing memorials and oral rounds, was team 2503. Congratulations. If the system says that it's a tie, it's because it's not considering the 85 threshold, as I explained before. The winning team was 2503. Congratulations to everyone, and see you in the next rounds. Judges, once again, thank you so much in the name of the whole Brazilian Institute of Moot Court Competitions, and hope to see you in a future competition.
Thank you, guys.
Bye.
Bye, everyone.
Thank you. Bye-bye.
Have a nice day.
Bye-bye.
Have a nice day. Nice to meet you.